Okay, Charmaine, I found a website that explains how to, or basically how this person went about suing the telemarketer. Um, when I first started the video, what I was doing was I copied it into a program, and then this program, what it does, it reads text. So I copied the text where it starts off, where it says, "This is how you do it," and then I recorded from then in the video listening to that output of that little program I had that reads. And I tried to scroll down enough to start, but it wouldn't let me scroll down to the place where I needed to start to tell you step by step how to do it. But anyway, you'll see as the video gets started, maybe 20 or 30 seconds, or maybe close to a minute, you'll see where I start highlighting the text as it's being read. So anyway, check it out.
Suing telemarketers, so how can you do it? Remember, I am not an attorney. I discovered this information on the internet and learned through trial and error how to go about the process. Just like you, I become incensed when I get those calls and they will not stop. I decided that the only way that these firms, especially the mortgage firms, will stop their behavior is if more and more people avail themselves of their right to private action. Here is how you go about it. 1. Log the calls. This does not need to be a complex process at all. Either utilize one of the tools I provide on this website or simply keep a notebook by the telephone. Each time a telemarketing call comes through, you want to do the following. If you have caller ID, mark down the telephone number and the caller information as presented on caller ID. Mark down the time and date of the telephone call. If your telephone service provider provides inbound caller information, as my Vonage service does, make a note in your notebook to make a copy of the applicable telephone records. Be nice to the telemarketer. Ask them to repeat their name, number, and who they are calling for. Act like you are a little hard of hearing if they seem suspicious. Ask them if they have a website. Sound like you are actually interested in what they are selling. Once you have gotten the aforementioned information, inform them that you are exercising your rights under the TCPA and that they must 1. Provide you with a written copy of their do not call policy within the next few weeks, and 2. They must place you on their do not call list. Please note, telemarketers are allowed at least one oops phone call after you tell them not to call anymore. You cannot count this oops call as a violation. Mark in your notebook that you have made these requests. Please mark any additional information, e.g. they were rude, they swore at you, they hung up on you. If I was able to get their website address, or such is easily figured out via Google, I like to follow up the telephone call by sending an email, preferably to an officer of the company, reiterating my demand for a copy of the do not call policy and that I be placed on their do not call list. In most cases, you will never hear from the telemarketer again. This is a good thing. If they do not send you a copy of their do not call policy within a few weeks, you can assume they are not going to. Regardless of whether or not they call you again, you can sue them for failure to provide the do not call policy. Personally, I do not bother as my goal has been met, they are no longer calling me. Nevertheless, they would be out of complaints, thus an easy $500 for you. Each time you hear from the telemarketer, after the one oops call, they are subject to a $500 fine payable to you. Do not accept what they say about their ridiculous assertions that they have 30 days to process such a request. The law is quite clear. In fact, the Direct Marketing Association, which seeks to advance the interests of telemarketers and similar folks, has this page which spells it out rather clearly. In fact, I submitted this page as evidence against one of the telemarketing firms. I like to send emails to the company after each call. It takes only a moment and shows that you have made an extra effort to assert your rights. Usually the emails I get back are nasty, you are a sue-happy scumbag, yada, yada, yada. Ignore the vitriol, but save the email. Judges in small claims court love to see this stuff as it is further evidence of the scumminess of these folks. To know and follow the local small claims court rules. Remember, the purpose of small claims court is to give the average person or business the right to pursue legal action without all the encumbrances of superior/federal court. I must point out that when I erroneously made the statement that attorneys are not allowed in a small claims courtroom, I have been quite correctly admonished by a few attorneys on this matter, most specifically by Laura Petel. Each jurisdiction is a little bit different. Some are highly restrictive as to when an attorney can represent a party in the case, others are not. As stated before, trust, but verify. I am not an attorney, so you need to be sure to check the local court rules and consider consulting with an attorney. I can tell you from my, albeit limited, experience that judges hate telemarketers just as much as you and I do. Know the upper limit for damages. There is a wide variance amongst the states. In the coming days I shall post this information directly, but the amounts are as wide as around $2,000 to over $10,000 in damages that you can seek. Generally, you are required to make a demand letter for the applicable amount before filing a claim with the small claims court. Be sure in your demand letter that you spell out each violation in detail and indicate the total you are seeking. This is also the point wherein you can make a settlement offer to keep from going to court. You must address the issue of venue. Some telemarketing firms will attempt to say that you have to sue them in their locale. From my experience, this is simply not true. Their actions caused you damage in your county, so you should be able to sue them in your county small claims court. I have been receiving some conflicting information on this, so please check back in a few days after I get some clarification. Be sure to verify this information with your local small claims court. Be very careful with the service of process. If the defendant is not properly served, your case will be delayed. Additionally, you must serve the proper entity. In my state of California, I get the information from the Secretary of State's website. Many states are the same wherein they shall display the agent for service of process. Although you are suing Acme Telemarketing Company, you are required to serve their official agent for service of process. Note that if your small claims court will serve the telemarketer via certified mail, as my local court does, you may wish to choose this option first. It is generally cheap, $10. If they avoid the certified letter, you can always find a process server. 3. Prepare your case and be ready for court. I obviously do not know all the court rules, however the following guidelines will generally serve you well in preparing and prosecuting your case in court. As always, consult your local small claims court. Many of such will have something called a small claims advisory clinic or the like. Utilize their services as they are free and they can answer many of your questions as to procedure. They cannot provide legal advice, however. Organize all your evidence in chronological order. Create a cover sheet which identifies each applicable item. Be sure it is clear and concise. Unlike TV, small claims actions rarely last more than a few minutes. Judges do not like to have to wade through documents that are poorly organized. Suggested evidence to include a copy of the TCPA statute, as noted earlier, a copy of the Direct Marketing Association guidelines, see above, a copy of all your phone bills, if you have inbound call reporting like I have, with the applicable calls highlighted, a copy of your phone logs that you keep by the telephone. I shall be posting some case law references and some information from federal R sources in the next several days to forestall efforts by telemarketers for fighting venue, applicability, etc. Before you go to court, make a copy of your evidence for the court and for the defendant. Eat a solid meal, do not drink a lot of coffee. Be on time. Dress appropriately, no hats, shorts, etc. You do not need to wear a suit, but you should be presentable. Picture what you would look like upon first meeting your spouse's parents. When you are in court, do not talk to the defendant. Everything goes through the judge. Hand all materials to the court clerk or the bailiff. Do not approach the bench unless the judge orders you to. Speak calmly and clearly. It is important to note that small claims courts are frequently overworked. The judge wants to clear the day's caseload as quickly as possible. Do not get into long-winded explanations. Best rule of thumb? Stick to the facts. You may be a little nervous your first time, such is okay. Everybody is. Just know that it will be over in a very few minutes.